Hola, buenas tardes a todos y todas. Bienvenidos a esta nueva reunión de nuestro Instituto de Investigaciones de Historia del Derecho. Hoy tenemos a una expositora de la Universidad de Nottingham. Va a hablar en inglés y va a acompañar con un PowerPoint en castellano. Así que yo ahora voy a darle la bienvenida y voy a presentarla. Hi, Sarah. Good afternoon. Welcome.
Thank you.
Welcome to our Instituto. We are very happy to have you here. And I just explained the audience that you are going to speak in English, but you are going to run a PowerPoint. Okay? Are you going to run it yourself?
Yes.
Okay.
Should I try sharing now?
Just a second. I'm going to introduce you, to read some lines about you, and then I'm going to give you the floor, right? Bueno, entonces les presento a nuestra expositora de hoy, que es Sarah White. Sarah White es doctora en Historia del Derecho por la Universidad de St. Andrews, en Escocia, Reino Unido. Es profesora adjunta de Derecho Fiduciario, se diría en español, en la Universidad de Nottingham, Reino Unido. Es codirectora del Centro de Historia del Derecho y la Gobernanza de la misma universidad. Fue profesora de Historia Medieval en la Universidad de Lancaster, también en el Reino Unido. Fue investigadora en el Instituto de Investigación Jurídica y Constitucional de la Universidad de St. Andrews, en Escocia, y sus áreas de investigación son la historia del derecho medieval, en la que ha estudiado cuestiones de procedimiento, la profesión jurídica y la interacción entre el derecho y la religión. Justamente hoy se va a referir a un tema que tiene que ver con el derecho procesal en la Edad Media. Así que le damos la bienvenida. Welcome, Sarah. It's a pleasure to have you here. So you can go ahead and the floor is yours and you can share the screen.
Okay. Does this work all right? Can you see this?
Sure.
Yeah? Okay.
Yeah.
Great. Well, thank you all very much for attending. Thank you for inviting me, especially thank you to Agustina and Viviana for their help, especially in translating my slides for me so that they're maybe a bit more understandable. As Viviana said, I work in a law school, but I am a medieval historian. So I hope the paper is interesting. I hope that the topic is something that is useful for you. Now, I'm sorry as well for speaking English. My Spanish is terrible. You wouldn't want to hear it. But anyways, thank you very much. So my paper this afternoon is going to explore procedure, legal procedure, and rhetoric. And I'm going to look at how these two elements combine in the arguments of lawyers who were practicing in the 13th century in England in the church courts. So, in the 12th century, the ecclesiastical courts, they started to develop a more usable procedural system. This was mainly in response to increased appeals to the Pope's court. Now, Roman law provided the necessary procedural framework, but because procedure was scattered in the Corpus Juris Civilis and canon law, it couldn't be dealt with in the usual kind of exegetical works. So they needed treatises to facilitate access to procedural law. So we have the emergence from the middle of the 12th century of these texts called ordines. Now, ordines outlined the proper sequence of steps for trials, for courts, and they put this in writing. So when you're thinking about how legal procedure and rhetoric might work together in theory, this is a good place to start. So I want to look at the treatise written by a very famous canonist, Tancred of Bologna. And then I want to look more generally at how you would build rhetoric into arguments, perhaps, and then move from theoretical to practical. and look at a question from the schools of law. So in doing this, I want to look at the tricks I sense that lawyers might use to try to win their cases in court. So Tancred of Bologna, as I said, he's a canonist. He studied law. He taught law in Bologna, and he wrote a procedural treatise or an ordo in about 1216. His ordo was one of the most popular procedural books throughout Europe, and it's a very, very good source for all kinds of topics. So what I'll focus on here is what Tancred says about how you can plead your case in court and how you can build an argument. So Tancred has a very short chapter, actually, on argument, and he says he mainly focuses on the procedural aspects and the order of actions that are supposed to happen in a courtroom argument. And he says that arguments should be made in the following order. So a plaintiff should propose those things that seem best to him to establish his case. Then a defendant responds to those things the plaintiff has set out. The defendant rejects the arguments using witnesses and proofs, or by introducing contradictory laws, or responding very reasonably. And the plaintiff, he says, should work on the statement of the case, but the defendant on his argument against it. Now, if the defendant wants to use an exception, he can do so, but what he accepts, he has to prove, because when you bring forward an exception in a case, you almost act as a plaintiff. So the defendant has to bring his own witnesses, his own documents, so on. After the arguments of a defendant, then the plaintiff can respond by, as he says, destroying the defendant's argument if he can, and the defendant can respond in the same way, and so on. So what we essentially have is a list of procedural stages. We have a plaintiff bringing a complaint to court. The defendant brings a response to that. The plaintiff can bring a rejoinder to the defendant, and the defendant responds, and so on. So you can see we have the normal turns and roundabouts and the exchanging of different points in a case. And this is what Tancred starts with in his description of argument, is these basic procedural stages. Now, Tancred also then suggests some of the topics you could argue in court about. So he says you could talk about the person or the jurisdiction of the judge. Is this a good judge for you to bring your case before? You could argue about the form of the libel. That's the claim, the initial claim. You could argue about the declarations and depositions of the witnesses or the people themselves. Maybe a witness was not a suitable person to testify in court. Or you could look at the validity of other proofs, so presumptions, documents, these sorts of things. So again, very, very procedural here. Then Tancred explains how the advocate of a plaintiff should use proofs to create a larger argument. He has to reconcile witnesses who don't agree and ensure that presumptions and documents have supporting witnesses too. Everything that he presents as proof should be carefully connected and all supporting each other. After he presents his proofs of fact, then there should be proofs of law. So arguments, as he says, based on laws and canons, arguments and reasons. After this, the defendant, the advocate of the defendant, has to respond, and he points out contradictions and variations in testimonies, and he argues whether the witnesses gave good reasons for their statements or responded to the questions. Are they the sort of people you should trust? Did they speak falsely? Those kinds of things. He could respond to any presumptions, any documents in the same way. And when it comes to the law that the plaintiff presented, he could explain how they don't suit the matter at hand, or that there are laws to the contrary. So what we see in Tancred then is a very, as I said, procedurally bound set of arguments. Everything is tied to the procedural stages of the case, and everything fits within what you would expect for like a normal court case. But Tancred also suggests a few simple tactics that you could use to construct your arguments rhetorically. He says the best arguments should be proposed first and last. So you can move the mind of the judge or move the spirit of the judge to believe you. So start with something strong, and then speak about any sort of mediocre arguments you have in the middle, and then save your last argument, your strongest argument, until the very end, so that he says those things that are heard last are better committed to memory. But there were also some more advanced tactics that an advocate could use when arguing for his client in court. And here's where we start to see some evidence, perhaps, of rhetorical training. Now, legal experts in this period would certainly have had an education in rhetoric at some point in their studies. Two of the most important texts for rhetorical education were Cicero's De Inventione and the Rhetorica ad Rhenium by Pseudo-Cicero. In the Middle Ages, this text was thought to be written by Cicero, but it's not. These two documents, these texts, were very widely circulated, so it seems very probable that legal experts practicing in England, especially if they had studied law in Italy or in France, would definitely have come across these. And advocates might have found that the rhetorical theory in De Inventione and Ad Rhenium would have been particularly useful for presenting the cases in their facts persuasively. So De Inventione and Ad Rhenium have a general outline of argumentation, so you can easily transfer it to other legal traditions. The first step is a statement of facts underlying the dispute, and then you have a discussion of the legal definition of events, so including which norms or rules might apply. These are establishing the facts of the case, you might say. Then you have issues of justifications, excuses, and then there are procedural issues. So in these instances, the procedure comes last. And these arguments are meant to be ordered from the most convincing to the least convincing, so outright denial to technicalities. Now, this is a very good model, and if you were a lawyer in the 13th century, this may have been very useful. But the other thing we should keep in mind is that the connections between the Ciceronian rhetoric and legal practice and the effect this might have on the actual delivery of a case in court is very hard to prove. So issues that we see coming forward are primarily issues of law and issues of fact, and it was more important often to point out legal authorities and a tradition than it adheres more to Gratian than it does to Cicero. And this is because the focus as we move into the 13th century, it becomes more and more tightly focused on written rather than spoken arguments. We see a lot more attention being paid to legal acumen over personal eloquence. So we have a legal tradition and a rhetorical tradition almost that emerges that is focused much more on things like logic and dialectic than other aspects of rhetoric. And because we start to see arguments being submitted in writing, this actually will limit the extent to which an advocate could depend on oratory to win his case. So in the ecclesiastical courts, at least, where an advocate was trying to convince a single judge, his technical command of the law might have actually stood him in better stead than rhetorical eloquence. So there's a combination of these two things that you would expect to see. Now, I want to illustrate how this might have worked a little bit in practice. So I want to look at a quaestio and the issues that this raises. So quaestio, questiones, these were written forms of disputations. These were from the law schools in this period. And they were based on the opposition of arguments pro and contra for cases with problematic interpretations. Now, the case I want to look at here is from a collection that was circulating in the Oxford schools near the end of the 12th, beginning of the 13th century. And this particular quaestio is attributed to someone named Master Nicholas de Aquila. He was a prominent member of the Oxford school, and this question concerns events during the crusade of Richard the Lionheart. And I think it sheds some light on the judicial status of crusaders at the end of the 12th century, but it's also quite a good example of how you might construct an argument in court and how you might use your sources. So, the quaestio poses a situation arising from the capture and imprisonment of Bishop Philip of Beauvais by Richard I's men in May of 1196. So, according to the quaestio, Richard was returning from his crusade. He was seized by the German emperor, and he was imprisoned under the supervision of the Bishop of Beauvais, who then went on and attacked Richard's lands in Normandy while the king was imprisoned. Richard was then released, and afterwards he attacked the bishop's lands in retaliation. So the bishop armed himself, and he put up a very strong defense. And chronicles, narrative sources from this period all agree that the battle between Richard and the bishop was a very bloody one, and it cost both sides almost all of their infantry forces. Richard was victorious in the end, and he imprisoned the bishop, who then appealed to the Pope. Now, according to one of the chronicle writers, Matthew Paris, the Pope wrote to Richard asking for the liberation of the bishop, and he calls the bishop his brother and his dearest son. But the king then took the chainmail coat belonging to the bishop and sent it to him, saying, "Is this your son's coat, yes or no?" The Pope, of course, recognizing that the bishop had worn armor into battle and had gone into battle as a secular lord, says, "No, this is not." And he leaves the bishop to Richard because, as he says, it is Mars rather than Christ who judges soldiers. Now, this issue raised a number of important questions for the canonists, and the question raised here is whether or not the bishop's appeal to the Pope was justifiable. So there are 3 points in the bishop's favor. The bishop was acting in self-defense. And even if he was fighting, fighting itself is not evil. And here there's a reference to Gratian's Decretum. This particular causa is on whether it is a sin to wage war. Gratian concludes that it is not. Now, the bishop was also then fighting to defend his land and the possessions of the church. And there's a citation to the same passage from Gratian, which explains that sometimes the pursuit of peace requires war. Now, the bishop had 2 responsibilities to fulfill. He had a duty as a bishop to protect the church, and a duty as a secular lord to protect his land. So, when he took up his defense of the lands, he was acting as a secular lord, and he was doing so legitimately. Now, this quaestio also references a very specific example here from the Third Lateran Council, where military action was authorized against a group called the Brabantines, who had conducted attacks against the church and church lands, and they were held to be enemies of the church in general. They were actually condemned as heretics at the Third Lateran Council in 1179, so this is very much recent memory. Everyone knows about this case. So those fighting against the Brabantines, this heretical group, were granted privileges very similar to crusaders. Now, I'll expand on this in a minute, so just keep that in mind. I'll return to that later. But the key argument here is that the bishop is very much within his rights to defend church property from attackers. Now, lastly, the third point is that it's dishonorable to hold a bishop prisoner. It's an offense to his office. For one thing, it's forbidden to retain control of church property and church goods. So the bishop himself, who is surely more precious than land or goods, you can't detain him in captivity. But the real question is, then, was the bishop within his rights to defend his lands? Should he have actually taken up arms himself? Now, in response to this, we have the arguments on behalf of Richard. So Nicholas, the author, first emphasizes Richard's status as a crusader. He says, whoever fights in the crusade enjoys papal protection. And here, actually, he cites the same chapter from the Third Lateran Council about defending the church from heretics. And he also says that if the king's possessions were seized while he was on crusade, he had the right to recover them. But you might say the right of recovery in this instance is being stretched quite far, because it seems to imply here the right to seize not only Richard's lands, but also the bishop's lands, and include the attack as well. So it's quite a stretch, as you might think. The other question, though, is if the war is just, thinking of just war theory, then maybe property taken in war does rightly belong to the victor. Now then, Nicholas argues that the bishop should obey the maxim from the Gospels and turn the other cheek. The bishop should not fight when attacked, even in self-defense. And indeed, he actually refers to the same passage of the Decretum from Gratian as the bishop did. So this passage closes with the conclusion that waging war is not a sin, but it opens with an argument that it is in fact a sin, which I'll come back to in a minute. Very confusing. But more practically, Nicholas argues that since the bishop chose to fight, he has to accept the consequences of his actions. If he's captured, he has to accept his adversary's right to imprison him because he brought this on himself. Now, Nicholas actually goes even further here. And you could see how this would maybe play out in the schools here, because it's a bit controversial. He argues that the bishop should be removed from his ecclesiastical position because he renounced all his clerical privileges by taking up secular arms, and because he caused and assisted in the perpetration of murder by going to war. Now, he cites a lot of different laws here, but the really key point is found in the digest. Now, it suggests that if the bishop dresses and appears and acts as a secular lord, he should be treated as such. Now, the passage is a bit problematic for a modern audience because if it says if a man speaks to a woman attired as a slave, he is liable for offense. But if she's dressed as a prostitute, there's no liability, no offense there. So in modern terms, Nicholas has essentially said that because the bishop dressed like he did, he was asking for it. So for this reason, the appeal is not justifiable. Now, the interesting thing about this quaestio is that the arguments for the bishop's right to defend himself and his lands and Richard's right to the same rest on the same core legal citations. So each argument involves many other references, of course, but the key ones are the Third Lateran Council on enemies of church property and protection of crusaders, and then the question of whether war is a sin. So we are presented with arguments for and against, and the task then is to determine which sources and sometimes which interpretations fit best. These are the skills of the emerging legal profession, and they're the skills of the masters in the schools. So, does the causa from the Third Lateran Council best support the bishop or Richard? Is the bishop permitted to defend his lands, the church lands, against attack? Well, to an extent, he can. Richard is hardly a heretic, though, and he's not intent on destroying church property, and we've been told the bishop is acting as a secular lord, so actually in his own interests, which kind of undermines his noble defense of the church. You might then ask, though, is Richard within his rights as a crusader to recover possessions that were seized while he was imprisoned? Well, it seems that he might be, but is he still within his rights to then retaliate against the bishop? That seems less likely. So you can see how these questions might be debated in the schools and what kind of angles you might take. Now, the passage in the Decretum poses similar questions, which is partially because of the form of the text. For those who are less familiar with the Decretum, its title, according to Gratian, the author, is the Concord of Discordant Canons. Gratian's intention with the text was to amass all of the disparate legal sources from canon law and resolve the contradictions they proposed. So while the causa starts out by saying war is a sin, Gratian eventually concludes through much discussion that this is only in particular circumstances. So war in general is not a sin in the end. So in this way, this is almost a quaestio in itself. And the case of the bishop and Richard's actions thus has opportunities for kind of pro and contra arguments on the surface, but also within the core texts of canon law. Now, Nicholas really surpasses all of his contemporaries in his expansive interpretation of privileges for crusaders, and this is really evident in his adamant assertion of Richard's rights to counter the bishop. And Nicholas pushes the boundaries of these concepts quite far in asserting that crusaders possess absolute rights to be free of any form of interference during the crusade. It's a stance that many of his fellow canonists wouldn't have endorsed. But the quaestiones here are meant to be contentious. They're meant to ignite debate. So there's 2 points really that I want to draw out then in looking at these texts. The first is that we're dealing with real events. These are not just thought experiments, and that the people discussing these events are actually very close to the action. The second is that these real events are then translated into the forum of the schools for discussion, suggesting that they involve more than just a simple solution to a problem. They're vehicles for working through how the law thinks in these instances, and by analogy then similar ones. So, to sum up, when we're looking for evidence of how legal argument worked in this period, how lawyers trained, how they practiced in court, we have a diverse set of sources. Now, I'm primarily speaking of English and Norman French situations here. We have additional sources if we include Italy, France, Spain, other European countries. But for the Anglo-Norman region at the end of the 12th century, it's a pretty disparate collection. We have some treatises on procedure, we have treatises on rhetoric. We know these were circulating in the area. Some of them were written in England or northern France. Others, like Tancred's work, were very popular, but we know they were here. We have quaestiones, we have distinctiones, all of these sorts of texts produced by the schools. And lastly, we do actually have some case material. And you might be wondering, why did you leave this out? This is because the case records in England, even until the end of the 13th century, record almost nothing of what is said in court. The documents that are submitted to the judge have only minor suggestions of any rhetoric, minor suggestions of legal sources, And this is not even until the end of the 13th century. There's several possible reasons for this. The main one is that the court only records what it thinks is important, and this is usually the proofs based on fact, secondarily on law. And then there's also the issue of survival. So the survival of the records is very uneven. So the few sets of arguments we do have, even in this late date, seem to be very much an anomaly. But that said, I think we can suggest a few conclusions. The first is that advocates who practice in the courts in this period were trained how to argue a case well. They used references to written law, they had a strong rhetorical structure, they knew what they were doing. The second is that the arguments themselves were probably done orally, they were probably spoken, and they were not presented in written form till much later. The key points were then made to fit into an increasingly institutionalized court system. So these aren't perhaps the most exciting conclusions, but I think they do give us some insight into legal education, legal writing, and legal practice in this period, which I hope will be helpful. Thank you very much for your time, and I look forward to your questions.
Okay, thank you very much. Now we have only a couple of minutes left, and we can start with some questions, and then we can get out of this Zoom and re-enter with the same link, right? Because this is a free Zoom, so we have only 40 minutes, okay? Entonces, podemos empezar a plantear, dejar planteada, aunque sea algún comentario o alguna pregunta que probablemente la doctora White la conteste cuando volvamos a conectarnos. Ahí hay una pregunta del doctor Parise. Can you read the question by Agustín?
Yes, I can.
Okay.
Yeah, I can start with that one. So Augustine says his question relates to flexibility. Did Tancred consider exceptions to procedural steps? If yes or no, why? In general, he talks about kind of exceptions to his procedural steps, not in his passages on argument, but in his wider treatise on why the case might go differently in different areas. But for the most part, he seems to be restricted to what we would consider to be maybe formalized exceptions. He doesn't anticipate, I say, the oddness of real world situations. Let's put it that way. So the exceptions that he suggests are all of the types of exceptions that you would be able to bring a formal complaint against. So for example, I can't come to court because I was not summoned correctly and therefore we cannot proceed to the next step. Something like that, which is very institutionalized in the church courts. So we don't see him thinking more widely than that. We mainly just see him looking at, if this, then that, if that, then this. And you get occasionally the little flowcharts, which again, often, if someone doesn't come to court, what do we do? But beyond that, he still stays very restricted, I suppose. Does that answer the question?
Okay, thank you very much. So now we are going to go out and then re-enter with the same link. There was another, I can see another.
I'll copy this one so that I can answer it when we come back in.
Okay, great. Bueno, entonces salimos y volvemos a entrar, así continuamos con los comentarios y las preguntas con el mismo link. Okay, see you in a couple of minutes. Bueno, continuamos entonces con la segunda parte de esta presentación de la doctora Sarah White. Había algunas preguntas por el chat, así que le vamos a pedir a la doctora que comience a contestar. Can you please go ahead with the answers?
Yes, of course. So the question is about the topics presented as well as the processes in the jurisdiction. So I give just a brief overview maybe of the topics and the process. So for the church courts, go ahead.
Sure, yeah. Go ahead. Yeah.
Okay. So for this period, for the church courts, we have jurisdiction over spiritual matters. So things like marriage, for example. We also have jurisdiction over church property, so tithes, benefices, appointment of priests, appointment of bishops, and we have jurisdiction over breach of faith, defamation, wills and probate, violence against clergy, and of course things like heresy and so on. But the majority of what we see are essentially property disputes. So who has the right to tithes? And then the second biggest category is marriage cases. So that's the main content. As far as processes go, we have a similar process to the Roman civil law system, but not quite the same, because the canonists looked at the Roman law system and said this is too harsh. So they modified it slightly to make it more Christian. So more opportunities for delay sometimes, softer penalties on occasion. But as far as the overarching structure goes, it's very Roman. And also just for general content, we're dealing with a hierarchical system of courts with courts of appeal. So we have courts of the archdeacon, courts of the bishop, archbishop, and the pope. So we have a system of appeals as well. Does that more or less answer the question? We have kind of a developmental period in this instance, though. End of the 12th century is when they're really getting good at procedure. Up till that point, it's a little bit informal and people are getting away with a lot. So this is why we need these treatises, is so that everyone is working on the same page.
Ok. ¿Alguna pregunta? ¿Algún comentario más? I wanted to ask you a question. Were these books used at the same time at canonical tribunals and also civil or penal tribunals? Were these authors cited in both tribunals?
Yeah, they were. So what we have actually is not a lot of distinction between civil and criminal law. Most of these are kind of published together. Later in the period, we start to see treatises specific to criminal law, for example. We see treatises specific to marriage law. But at the end of the 12th century, beginning of the 13th, it's very general still. So we'll get some specifics here and there, but not as much as we would like. The other thing that we see a lot is that rather than citing these treatises, a lot of the time people will just cite Roman law or just cite church councils. So you go directly to the source, you use the treatise as a access point, and then you go and you cite the digest or you cite the code. And so you have the authority behind that. Near the end of the 13th century, we start to see commentaries by famous lawyers from Bologna, particularly, being cited as authority as well. But this is less so in this early period.
Okay. What I saw when I researched in trials from the 18th century, at the courts of Buenos Aires, for example, I saw these religious treatises cited in civil procedure. Yeah, yes.
This is very nice, because one of the questions I've been thinking about, some of these treatises use the Bible as a source, but almost like maybe 2 or 3, because this is not a legal source for them. This is a moral source.
Okay.
But I am wondering sometimes how much people were still thinking along the lines of a moral argument rather than a legal argument, if that distinction makes sense.
I did not mean that I saw these authors, right?
No.
But I saw some books of these religious writers cited in legal procedures. That is what I meant. Yo lo que quise decir es que este tipo de autores estos tratadistas que trabajaron mucho derecho canónico, también se ven citados en los expedientes judiciales. And the same, I guess, that civil jurists were also cited in canonical courts.
Yeah.
Am I wrong? Or is
No,
that correct?
I think you're right, because this is what we see as well. And because when you're thinking in terms of authority, the best authority that you have is the Roman law sources, long and glorious history, and the Pope. These are the two most authoritative things you can say. So this is what people turn to the most. The slight problem, of course, which is what we see coming up in these arguments, is that these sources don't agree. So you say one person says, but Justinian, he says these things, and the Innocent III says these things, and you have to choose which sources fit best.
Lo que yo decía, lo que yo le comentaba a la profesora era que así mismo en los tribunales, le preguntaba si en los tribunales religiosos se citaban autores que no eran religiosos y no eran juristas de derecho canónico, y me dijo que sí, que uno puede encontrar citas de autores que no sean de derecho canónico. Así que, bueno, acá hay, I see there are some commentaries in the chat. Can you read them?
Yes, I see there's a question from Agustin about the availability of the books. Yeah, okay. So we can look at library lists from this period. Obviously, they are not always complete, but from the library lists, good question. From the library lists, we know that most churches and monasteries, like certainly bishops' churches, had a copy of the Corpus Juris Civilis. Most of them had copies of the Decretum and copies of papal decretals. So the core texts you can get everywhere. The treatises we have, they seem to be very popular. So obviously some are better than others. So there are some where you have one copy, two copies, maybe they weren't very good, maybe they weren't very popular, who knows. But then there are others that survive in 30, 40, 50 copies in England, on the continent. And from these ones, we can tell that these were fairly popular books. The things that are also very interesting, there's a text I've been looking at recently that is annotated by somebody as well. So not like a formal gloss, so there's formal commentaries that go around, but this is someone making notes with case references. And this is very interesting because this suggests to me this is a working document, right? It's not just for scholars, it's not just for learning. This is somebody sitting maybe in court taking notes. So they seem to be well used and pretty popular. Again, depends on the text. Tancred's very popular, other ones not so much, but yes.
There's a question by Héctor Míguez. Héctor, ¿por qué no te abrís el micrófono y haces la pregunta?
I have two questions. The first one is, do you know what happened finally in your case? And the second one is, do you have all the medieval legal precedents available in databases nowadays?
Okay. So for the first question, what we know about Richard and the bishop's case is that the bishop was kept in prison by Richard for quite a long time. The Pope refused to grant the bishop freedom, but he eventually ransomed himself. He wound up enough money to pay Richard to release him. And Richard said yes, because Richard always needed more money for the next crusade. He'd spent most of England's income on the first crusade and his own ransom, so he needed a bit more for the coffers. So that was how that one concluded. The interesting thing about the quaestio, so the legal question of it, is that it is left very open-ended. So I think the sense that you get is that there's not necessarily a right answer, but there are clever answers. So you would present these two sides, perhaps have students like we do today, argue a case in a seminar, something like this, and you could see that maybe playing out in that way. But yes, the real answer is ransom. For the legal precedents available in databases, some. So for Roman law, the sources are generally quite accessible, and there's a recent database, I think, that someone was building. I don't know if it's out yet, looking at all of the different chapters in the novels and the various precedents that come out from that in the last book of the digest, pulling out kind of the basic precedents. I don't know whether that's up yet or not. For canon law, there is another database called the Clavis Canonum, which is essentially a database of all of the opening lines of different canons, and you can search by topic. That was getting revised, I think. This is Linda Fowler-McGurl's project, but it's being revised now by Clemens Radl. So the Clavis website, though, I think is up. I'm just going to actually check this because I'm pretty sure you can access it. Whether or not it's working is another question, because, you know, people build these databases and then leave them orphans on the internet. But there's this one for the canons. Aside from that, it's not very holistic, I suppose. Things are published in bits and pieces, but those are the main ones.
Okay, thank you very much. ¿Alguna otra pregunta, algún otro comentario que le quieren hacer a la doctora? Bueno, no veo ninguna mano levantada. I don't see any hands up. So, thank you very, very much for your interesting lecture today. I guess that you won't have any problems if some of the participants in this lecture want to get in touch with you just for a question or for some information they need. Can we share your contact?
Yes, of course. Yes, by all means, email me, get in touch. I can send you the link for our research center website as well. Sometimes we do online events and so on. So if anyone's interested, we have a mailing list.
Okay, great. Entonces ella va a poner a disposición de los asistentes los links para que accedan, ¿no?, a ese material. This is very useful for us.
Okay, excellent.
Because what happens to us, or maybe what happened to me, is that we usually search in databases that maybe are in Spanish. So we miss this information, but because we are putting the websites that are in English, we keep them aside, so we miss them. So it's very useful for us if you can provide us with that information. Lo que nos pasa a nosotros, que nosotros generalmente buscamos en castellano y estas cosas se pierden, no se encuentran. Como ella está acostumbrada a buscarlo en inglés, lo encuentra mucho más fácil que nosotros. Así que, okay, Sarah, thank you so much for sharing your research with us today. And it's been a splendid opportunity to know you. So now you know us and we know you.
Thank you so much. It was wonderful to see all of you online. Thank you very much for coming. I appreciate it.
Okay. Thank you very much. Gracias a todos y nos estamos viendo la semana que viene, que lo vamos a tener a Antonio Luque Reina de España con una presentación en castellano. Bueno, muy bien. Muchísimas gracias. Hasta el jueves que viene. Thank you, Sarah. Bye-bye.
Thank you. Bye-bye.